Hello, good afternoon, guys. Welcome to MK Convenience Brokerage. My name is Mohammed. In this video, I'm going to be talking to you about the part 3 of the Notary Public Test for the New York State. Now, as you know, Notary Public laws, rules, regulations vary by state by state. Keep in mind, um, I've talked about part 1, part 2. I'm going to go over part 3, which is the last part. Um, so some of the stuff will be kind of repetitive, obviously, because no republic rules regulations are not that much different. It's the way you execute those things. You'll learn. So how I usually do this type of things, if you watched part 1 and 2, I usually go on, basically going on which one is the most important one, and obviously which one came during the test. Um, I will also have description on the link to go where to study from. This Quizlet.com, excellent place. When if you want to study, you could go there. There's also other websites as well, but some of the websites you do have to pay for that. So keep in mind with that part. So let's get started with part 3 and the last part. Section 304, proof by subscribing a witness. So basically, this is used where basically what they're saying is, if you're ever notarizing something for other people, if they have a witness right next to them, they're basically witnessing, saying that this is the person, I'm his witness. You're not only notarizing that person, and also, but you're also notarizing for that witness as well. The witness information you do put in your notary book, if you have one, saying that this was the person, this is the witness that was sworn right before me as well. So keep in mind, that's one of the questions they might be able to ask you as well. 306, certificate of acknowledgement or proof. A person taking the acknowledgement or proof of conveyance must endorse thereupon or attach therefore a certificate signed by himself stating all the matters required to be done, known or proved on the talking of such acknowledgement or proof, together with the name and substance of the testimony of each witness examined before him, and if a subscribing witness, his place of residence. So basically, they're saying that the person that's right before you, he's the person that acknowledgement. Yeah, this is the paperwork. This is what it is. These are the people that are going to be. Basically, that's what they're trying to say. If you ever guys got your paper notarized, you know how if you buy, let's say, a home or stuff like that, there's a lot of stuff in the stuff in what you call in the paperwork where you don't really see it. So you'll see other people's name inside there as well. Basically, that's what they're saying. That your acknowledgement and you're proving that this is what it is. Uniform forms of certificate or acknowledgement or proof with the state. The certificate of acknowledgement within the state or a conveyance of an instrument in respect to real property situated on this state by person must confirm substantially with the following form, the blank being properly filled. As you can see, this is something that you see in the Notary Public exam as well. They'll ask you certain way of the question, but basically whenever you notarize something, this is how it is. State of New York, county of whatever country you're in, on this day, on this year, before me the person actually appeared, or proved to me by showing you whatever evidence. What can be the evidence? Evidence could be a driving license, evidence could be a passport, as long as it shows that this person is resident in your place. Keep in mind with that part. They show you multiple parts as well. This is another part of how to, the Notary Public. If somebody does come to you, this is how it might look like. Certificate of acknowledgement or proof taken under section 300 of this article shall include the additional information required by that section. Again, keep in mind with that part. This is also uniform forms of certificate of acknowledgement or proof without the state. Basically, as you can see, the state is not there, but this is also part of it as well as the state, District of Columbia, territory, possession, or as you can see, this is the proof without the state, and this is the proof within the state. As you can see, to say state of New York. So keep in mind with that part. As you can see, this is the whole article. You can read this on your own. Obviously, I don't want to go over every part of it. It'll be too much of a big video, but I just want to go over certain key aspects of it. Officers guilty of malfeasance is liable for damages. Keep this in mind. This is the bold part, and in small paragraph there might be a question on this as well. An officer authorized to take the acknowledgement or proof of a conveyance or other instrument, or to certify such proof or acknowledgement, or to record the same, who is guilty of malfeasance or fraudulent practice and execution of any duty prescribed by law in relation thereto, is liable to damage to the person injured. What does it mean? Putting in simple English, Let's say, for example, if you are a notary public, a licensed notary public, somebody comes to you and say, "Listen, I want you to notarize my father's, death certificate," or let's say you want to notarize your father's bank account so that money could transfer over to you. Guess what? The father's not there. That the son is there, who claims to be the son. You don't know that. I mean, obviously he's saying it's his father, but you don't know that. Now you notarize without committing due diligence, and that person you notarized, the person that he said was his father, is somebody that he doesn't know, but you notarized it without asking for the other person's notary signature as well, which is already pre-filled. Guess what? You're going to be liable for it. Keep in mind with that part, it is very, very important as a notary public that you do your due diligence. When conveyance of real property not to be recorded. This is important as well. As you can see the stars over here. Keep this in mind. There is a question in the test about this as well. A recording officer shall not, which is the notary public, shall not record or accept for record any conveyance of real property unless said conveyance is entirely and the certificate of acknowledgement or proof that the authentication thereof other than the proper name therein, which may be in another language, provided there are written English letters or characters shall be in the English language, or unless such conveyance, certificate of acknowledgement or proof, and the authentication thereof contained by that have attached thereto to a translation in the English language, duly executed and acknowledged by the person or persons making such conveyance and proven and authenticated. Basically, what this paragraph is saying, if somebody comes to you, let's say it's a deed on their home, right? Make sure it's in English. You cannot notarize a document that you don't understand. Think about it this way. I bring a document in let's say Spanish, but you don't speak Spanish. You don't understand Spanish. You can't notarize that document because you don't know what the document is saying. You know if the document is stating that this person let's say the document in Spanish, you don't know what it means. It might be saying that all if this person dies, all the money belongs to me. You don't know, but guess what? If you notarize that part and that and something liable comes out of it, you're going to be held liable because you notarized the document. Keep in mind with that part. That's what it's saying that. There's a special note. By reason of changes in certain provision of the real property law, any and all limitation on the authority of a notary public to act as such in any part of the state have been removed. A notary public may now, in addition to administering oaths or taking affidavits anywhere in the state, take acknowledgement and proof of conveyance anywhere in the state. The need for a certificate of authentication of a county clerk as a prerequisite to recording or using evidence in this state of instrument acknowledgement or proof has been abolished. The certificate of authentication may possibly be required for the instrument to be recorded or used as evidence outside the jurisdiction of the state. Keep in mind with that part. Now, banking law is also important. If the rental fee of any safe deposit box, this is important. This is something that they do ask you in the test. It's very important to know with that part. I'm going to explain to you what this banking law is. If the rental fee of any safe deposit box is not paid, or after the termination of the lease of such box, and at least 30 days, keep that in mind, 30 days, you have to know the days as well. So at least 30 days after giving proper notice to the lessee, the lessor, the bank, in the presence of a notary public, open the safe deposit box. Remove the inventory, the contents. The notary public shall then file with the lessor of a certificate under seal, which states the date of the opening of the safe deposit box, the name of the lessee, and the list of contents within 10 days of the opening of the safe deposit box. A copy of the certificate must be mailed to the lessee in the last known postal address. You go to any bank. As a notary public, I'm going to give you a scenario. The bank now, most banks have their own notary public, but let's say the bank does not have their own notary public. Now, they see a safe deposit box has been unclaimed for. The person, whoever it belongs to, yet no one has any clue who that safe deposit box belongs to. Now, what do they have to do? So within 30 days, after giving the notice to that person doesn't answer, they have to call the notary public. The notary public has to come there, and without him, the safe deposit box cannot be opened. He has to see the safe deposit box open, and he's the one, or she obviously, is the one that writing all the information down, all the context, they have to write it down. And within 10 days of opening that box, the copy must be mailed to whoever the person that belongs to. Basically, that's what it's stating that. Most banks, realistically speaking, have their own notaries. So guess what? They're not gonna get a person from outside a notary public. Now, if the bank does not have their own notary, now they'll ask a notary public, whoever it is, a friend, family, whoever it is, to come and get that. Without the notary public, the thing cannot be open. Keep in mind, Rule 3113, Civil Practice Law and Rules. The rule authorizes a deposition to be taken before a notary public in the civil proceeding. Domestic relation law, a notary public has no authority to solemnize marriage, nor may a notary public take the acknowledgement of parties or witness to written contract of marriage. You are a notary public. You cannot get people married. Keep that in mind. That might be in the test. Your job is to notarize document. Now, who does that? Well, guess what? An ordained minister has that. Ordained minister could go and get people married. They're the only ones that have the power and authority to get people married. Because the way they do it is a little bit different. They have to go to the county clerk office. They have to get registered. They get a certification saying they're ordained minister on this such and such a date. You're not. A notary public does not have that. You do not get people married. You cannot get two people coming to you saying that I want to get married. Can you notarize my document stating that I'm married? No, you cannot do that. Keep that in mind. People will play a lot of games when it comes to notarizing documents. They'll come with getting a fake ID or ID from another country, not giving you the exact address. So a lot of times there's a lot of scam going on. When in doubt, you don't know what it is, don't notarize it. That's my best advice that I could give a person. You don't know it, guess what? Don't do it. Simple as that. Moving on. Public officer law. Official oaths and permits that the oath of a public officer administered by notary public. This is something that I would usually not really care about reading through it, but you can do it on your own, to be honest with you. Judiciary law, none but attorneys should practice in the state. So going over this, all over this, basically is saying that you're not an attorney. I'll read this a little bit. No natural person shall ask or receive directly or indirectly compensation for appearing for a person other than himself as attorney in any court or before any magistrate, or for preparing deeds, mortgage, assign, discharge, lessee, or any instrument affecting real estate. Wills, concealed, or any instrument affecting the deposition of property after death or descendant estate, or pleading with any kind of action brought before any court or records in this state, make it a business to practice for another attorney. Basically saying that attorneys are different. When they become lawyers, they end up becoming their own. What's the word I'm looking for? They also become notary public as well. But since they practice law, they don't have to take the notary public exam. They become exempt from this. But notary publics are not lawyers. They are not. You cannot give anyone advice. This is something that does come into the exam a lot. That are notary publics allowed to give advice to this person? No, you're not. You cannot indirectly or indirectly give anyone advice, because notary publics are not lawyers. You're not any. You cannot give advice. You cannot directly or indirectly say that you know a lawyer. You go to them. You cannot even do that as well. So keep in mind with that part. As you can see over here, law students who have completed at least 2 semesters of law school, or person who have graduated from a law school who have taken the examination for admittance to practice law in the courts over court in the state, immediately available after graduation from law school, or the examination immediately available after being notified by the Board of Law Examiners that they failed to pass the exam. Well, basically saying that if you graduated, you're not going to end up taking the notary public exam. That's basically the whole thing. That's what they're trying to say. Violation of certain proceeding. Obviously, you will be guilty of misdemeanor if you violate these sections. It's good to know. Power of courts to punish for criminal contempt. The Supreme Court has power under this section to punish for a criminal contempt any person who unlawfully practiced or assumed to practice law, and a proceeding under the subdivision may be instituted by the court. Basically, you're gonna get hit. You're gonna get arrested. Illegal practice of law by notary public. If you do that, make sure you know the consequences. Okay. Wills. The execution of wills under the supervision of a notary public acting in effect as a lawyer cannot be too strongly condemned, nor only for the reason it means an invasion of legal profession, but for the fact the test Testator thereby run the risk of frustrating their own solemnly declared intention by rendering worthless maturely considered plans for the deposition of state, whose creation may have been the fruit of lives of industry and self-denial. Well, basically, this is a court case. I would not recommend any notary. It's up to you. I always give good people advice. I would not recommend doing wills. Wills are something that, it's something you don't want to get involved with, to be honest with you. You don't want to get involved with wills. You don't want to get bothered by it. Do something small. Believe it or not, it's not worth the money with wills, because wills they always, oh, you know what? I notarized this for my for a friend of mine who's wills, but guess what? Now they go to court. It's problematic. Guess what? You don't want to get dragged into that mess. It's better off to stay far away as possible when it comes to wills. Wills, deeds, anything related to home, like purchasing a home or transferring something to another person's name. Small, what I mean by small, it's basically you're notarizing somebody. Let's say if they're becoming a police officer, they have something to notarize that. Let's say if somebody is purchasing a car, something, for business related, notarize that part. Somebody's going for a job interview, they want to know if this is the person, this is their credential. You look into the paperwork, guess what? That's the person. You notarize that. That's what I mean. Something small and easy. Don't do any complex. Unless you're a lawyer, then you obviously you have the knowledge, you have the wisdom to do the wills. But if you're not, don't get bothered. Notaries must not act before taking and filing oath of office. The public officer law provides that a person who executes any of the functions of a public officer without having taken and duly filed the required oath of office is prescribed by law is guilty of a misdemeanor. A notary public is a public officer. Guess what? Once you become a notary public, you become a public servant. Don't start notarizing stuff for other people unless you get the license. Basically saying, get the license, then start doing notary. Passing the test doesn't mean that you became a notary. You getting the license on your hand, showing that this is your license. That's what it means. You became a notary. Fees of public officer. Each public officer upon whom a duly express imposed by law must execute the same without fee or reward, except where a fee or other compensation therefore is expressed allowed by law. An officer or any other person to whom a fee or other compensation is allowed by law for any service shall not charge or receive a greater fee for reward for that service. Basically, they're saying that if you are a notary, obviously you want to get paid and everything, but keep in mind that if they don't pay you, you cannot ask for the money, basically, because you are a public servant. Public servant meaning that you're helping other people out as a servant. Like you get paid by the state, but notary publics don't pay. It's kind of like a loophole, you could say, but you rely on whatever amount you ask. Just keep in mind that's what they're basically saying. Fees for administration, as you can see, an officer is not entitled to a fee. That's the most important part. You're not entitled to a fee for administering the oath of office to a member of the legislature or any military officer, to an inspector of election, clerk of the poll, or to any other public officer or public employee. Guess what? All these people, they're exempt. Executive law. Misconduct by notary and removal from office. A notary public who, in the performance of the duty of such office, shall practice any fraud or deceit is guilty of misdemeanor. Basically, that's what's gonna end up getting punished. Sentence to prison for felony. Maximum term of sentence. The maximum term of indeterminate sentence shall be at least 3 years. A number. You can always make sure to remember these things. For Class G felony, it's 7 years. For Class E felonies, it's 4 years. Perjury. Once he's guilty of perjury, if he has stated or given testimony on a material matter under oath of revelation as to truth, therefore that he knew the statement or testimony would be false and willfully made. Perjury. It is important. Keep that in mind. What perjury is something that is very serious. Keep in mind with that part, it's like lying under oath. If you have notarized somebody's document and you end up lying that you have not, guess what? They're going to know it because your stamp and everything is there. Why would you lie in certain things like that? It's just mind-boggling. Always keep records. If you're going to notarize other people's documents, I highly recommend keeping a record for yourself, so knowing that you are notarizing other people's documents. Because if when it comes to court, you're not going to remember, to be honest with you, you're not going to remember if you notarize somebody's document 5 years ago. There's no way. We're all human beings in the end of the day. We might forget who we notarized. It's like, who the hell is this guy? I don't even remember who I notarized. To be honest, that's how it's going to be. So keep in mind, if you're gonna notarize some things for somebody, so just make sure that if you are notarizing it, write down the information, the basic pedigree information. Have a certified, like a notary book. You could buy it from Amazon. You could buy it from the notary store. Just buy the cheapest one. At least you can get the basic pedigree information, the date, the time, the what are you notarizing. All those things makes a big difference. Okay, forgery in the second degree. These are something now. It comes with now they're telling you about what happens if you do commit a violation or a misdemeanor or a felony, whatever the case is. A person is guilty of forgery in second degree when with intent to defraud, deceive, or injure another. He falsely make, completes, or alters a written instrument, which is basically what they're saying all over here, which I highly recommend you as well. That if you forge somebody's notary, you're gonna get punished in the second degree. Basically, that's what it is. So keep in mind with that part. Issuing a false certificate. A person is guilty of issuing a false certificate when being a public servant authorized by the law to make or issue official certificate or other official written instrument, and with intent to defraud, deceive, or injure another person. Basically, you're doing that. You're guilty for that part. Official misconduct. A person is guilty of official misconduct with intent to obtain a benefit, to injure or deprive another person of benefit. All these things are basically, how it is. Notary must officiate a request. The penal law provides that an officer must, before whom an oath or affidavit must be taken, is bound to administer the same when requested or refuses to do so in a misdemeanor. Advertising. Actually, yeah, it's a misdemeanor. Advertising. A notary public who is not an attorney licensed to practice law in the state of New York shall not falsely advertise that he or she is an attorney licensed to practice law in New York State. So keep in mind with that part, you have to let people know that you're not an attorney. You have to let them know. A notary public who is not an attorney licensed to practice law in the state of New York and who advertises his or her service as a notary public in a language other than English shall include in the advertising the following disclaimer. You have to have that. I am not an attorney licensed to practice law and may not give legal advice about immigration or any other legal matters or accept fees for legal advice. Disclaimer shall be printed clearly and conspicuously and shall be made in the manner of language as is the advertisement. Okay, so all these languages are over here, they have to write it down. Acknowledgement. A form declaration before a duly authorized officer by a person who has executed an instrument of such execution is act and deed. Basically saying that, this person has come before me, this is who I am. That's what basically definition of acknowledgement is. Actually, from this part is all definitions from here on. The bulk of the notary public, we went over the main things, but I highly recommend going over definition and general terms. Let me see which one actually came. Affirmation is one of them that does come. Let me see. These are something I highly recommend just reading it even once, so knowing what it is. This is something that comes up ex parte from one side only. Keep in mind with that part. Jurad is also one of them. They ask you what is a jurad. They actually give you an advice. So this is what jurad is over here. Let me see what else. They could ask you from any part of over here. I highly recommend reading all of this. This is something that's very important. I will memorize all this because they do ask you how much of a swearing witness fee is $2. Appointment as notary public. What do you have to do? Total commission is $40 appointment fee and $20 filling an oath of office. So altogether it's $60. Change of name and address is $10. Duplicate identification card is $10. All this is I highly recommend reading the schedule fee. Venue is also one of the questions that did come up. But other than that, to be honest with you, whatever came up, I explained to you. But it is something that they might ask you from any part over here. I highly recommend reading this even once and twice before you take the test. Rather than reading the whole bulk of it, I would highly recommend reading the rules regulation over here. So basically, that's about it. This is the bulk of the notary public. Keep in mind with that part, the test don't let the test take advantage over you. What do I mean by that? People thinking that notary public test is easy. It's actually not. It's in the middle. It's not that hard, but it's not that easy. You underestimate this exam, you're not gonna pass. I'm gonna be honest with you. Even you might study all day long, it doesn't guarantee you're gonna pass. The questions are tricky. Some questions are tricky. Some people didn't pass this on the first time. Some people took it the second time. The first time they were overconfident or they got too scared. Just take it easy, relax. What's the worst that's gonna happen? You're not gonna pass. Guess what? It's not the end of the world. You take it again. Even if you have to take it 50 times, you will pass at the end of the day because you'll know what the question they're asking for. The first time you take the test, you don't pass. Guess what? You know, especially when you know you're not gonna pass, just look at the questions. At that time, your objective is not passing. Your objective is looking at the questions. You know what? I think I didn't know the answer. Visualize that question. Go through it. When you go home, right there, especially bring the booklet. Guess what? You know what definition to ask. Right there, if you have the booklet, give it a star. Guess what? If you do take it again, do you know what? They ask you the same question. Guess what? You just got bonus points from there. That's how I recommend doing these tests. Take the test. Get prepared. You didn't pass. Think about the questions that you think you didn't get right. Right there, open up the book when you go outside. Obviously, look at the question. Okay, I think I didn't get this right. Let me put a star next to it. You know what? This is the definition they might ask. Let me see. You know what? I forgot the fee for this. Let me put a star next to it. 3 or 4, 5, 6 questions at least you'll get top of your head because you just came out from the test. You know what the questions are asking. So keep in mind with that part. With that being said, this was the final part. Hopefully I covered every part of it. I know I skipped certain parts. I felt like those parts were not important, to be honest with you. But they might be in your perspective because you are taking the exam. You want to know everything. But keep in mind with that part, I only try to go over what questions they might be asking for. With that being said, thank you again, guys, for watching this video. Hopefully you guys enjoyed it. Hopefully you guys learned the Notary Public License Law for the exam. Thank you again, guys. And make sure, guys, please don't forget to comment, like, subscribe, and follow my page, YouTube page. Thank you again, guys, for watching this video. Again, hopefully you guys enjoyed it.